Good afternoon, everybody. My name is Ben Barros. I'm Dean of the University of Toledo College of Law. I'm delighted to welcome you to today's National Stranahan National Issues Forum lecture. The series began in 1990, supported by an endowment from the Stranahan family. The forum is a joint program of the University of Toledo College of Law and the college's Federalist Society, with the purpose of addressing issues of national importance through the lens of the American legal system. Over 40 of the nation's leading legal academics, economists, historians, political scientists, public policy professionals, and judges have participated in the National Issues Forum over the past 20 or so years. To introduce today's very distinguished speaker, it is my pleasure to turn to Lee J. Strang, the John W. Stepler Professor of Law and Values at the College of Law. Professor Strang came to the College of Law in 2008 after teaching at 2 other law schools. He is an accomplished teacher and scholar. Among many of his many other duties, he is the advisor to the College of Law's Federalist Society chapter and coordinator of this lecture series. Please join me in welcoming Professor Strang.
Thank you, Dean Barros. The Stranahan Lecture Series, more generally, is a necessary contribution, a necessary perspective to our university's debate on important issues. It's therefore my pleasure to introduce this fall's Stranahan lecturer, Judge Amul R. Thapar. Judge Thapar, a judge on the U.S. Court of Appeals for the Sixth Circuit, is a graduate of Boston College and UC Berkeley School of Law. After law school, Judge Thapar clerked, entered private practice, and was then an assistant U.S. attorney for the Southern District of Ohio. Judge Thapar was appointed as the U.S. Attorney for the Eastern District of Kentucky in 2006. A year later, President George W. Bush nominated him to be a district court judge. And Judge Thapar was unanimously confirmed by the Senate in 2007 when he became the first federal court judge of South Asian descent. In 2017, Judge Thapar was appointed to the Sixth Circuit, and during his time in the court, Judge Thapar has authored numerous important opinions on a variety of important topics, ranging from non-delegation, criminal law issues, and even the use of corpus linguistics in legal interpretation. While performing these judicial duties, Judge Thapar has also found time to engage in legal scholarship on interpretation as a general matter, the role of judges, and other topics, and his scholarship has appeared in the Yale Law Journal and the Michigan Law Review, among others. In his Stranahan lecture today, Judge Thapar will draw on his extensive experience as a judge and law enforcement officer to propose criminal justice reform that aims to promote public safety, reduce recidivism, give defendants more agency over the criminal process. Judge Thapar will speak for approximately 35 to 40 minutes, leaving about 15 minutes for your questions and comments. Please join me in welcoming Judge Thapar.
Well, thank you very much for having me. Of course, my technology froze as I got up here. So first, I want to thank the Federalist Society, the Stranahan series, and everything else. I'm glad you all have the opportunity to hear from a broad group of speakers. I think it's really important that you hear from people often that think differently than you. And today I want to talk about indigent criminal defense and criminal defense in general and how maybe we should rethink it. And I'm going to start with just a kind of non-remarkable presumption that criminal and civil attorneys are different. Courts have an obligation, in fact, to treat them differently. So civil attorneys, as you all know from your Civ Pro class, are bound by Federal Rule of Civil Procedure 11. And that allows other attorneys and the court to seek sanctions for a frivolous motion or for taking knowingly frivolous positions. And this is obviously a good thing. We don't want lawyers taking frivolous positions. But if you look and study, there's no such boundaries for criminal attorneys. And you may say, well, why not? Why wouldn't we have such boundaries for criminal attorneys? Well, for a couple reasons, right? When everyone is charged, they show up in court, and the first thing they do is they plead not guilty. Well, if you have an attorney pleading for them and it's clearly frivolous because they're guilty, that would be a problem if someone could seek sanctions for that. And what about putting the government to the proof for interstate commerce, for example? So ABA Model Rule of Professional Conduct 3.1 prohibits lawyers from making frivolous arguments, but permits criminal defense attorneys to put the government to the proof on every element. Interstate Commerce Clause, chain of custody. So let me give you a couple examples of why this is important. So Christy Love is a defense attorney in Kentucky who I actually hired when I was U.S. attorney as an AUSA. Unfortunately, she left being an AUSA, or maybe fortunately, to become a criminal defense attorney, meaning she was very good. She got there and she recognized that sometimes law enforcement agents aren't as good with chain of custody as one would think. And so what did she do? What rarely happens is she contested the chain of custody. Well, I happened to be a judge at the time, and we held a hearing. And guess what? There was a chink in the armor of the government. So why would you contest chain of custody if it looks pretty ironclad? A, you get free discovery, which never hurts when you're dealing with the government. But B, you get the opportunity to see if they can dot the I's and cross the T's. Now, I'm not a fan of, as you may know, I'm probably considered a little bit tough on crime, and I'm not a fan of letting the guilty go free, but the point is that we want to protect all the innocent by putting the government to the proof and making sure they dot their I's and cross their T's. Let me give you another example in this kind of same realm. So I had one thing you probably shouldn't do if you're a criminal is kill the government's witnesses. And I had a few defendants in a death penalty case where the United States government was seeking the death penalty. And Kent Wicker represented one of the defendants. Kent Wicker is one of the best criminal defense attorneys in Kentucky. And in that case, he found another chink in the government's armor in that some of the evidence that the government had disappeared. And let me walk you through what's happened. A cop says, geez, I just looked at the evidence log. That piece of evidence I actually threw out. And what happened is there was an experienced detective. New detective comes. He's going through the drawers and finds some evidence. It should have been logged, wasn't logged, and he tosses it. Okay, so the prosecutor says, well, we have to disclose that. Let me know what it is. And so he writes up a report, and the prosecutor turns the report over. Well, Kent says, this sounds suspicious. And so he calls he moves to dismiss the case for prosecutorial misconduct and says that the government was destroying evidence. Well, this is a big accusation. But he has this report, so we go ahead and conduct a hearing in an abundance of caution. When someone's life's on the line, you're probably going to conduct a hearing in those circumstances. And he puts the officer on the stand, and the officer says, why'd you destroy the evidence? And this is what the officer had in the report. It was consistent with his report. Well, I called the lab, and I talked to the lab tech about this, and it was a knife that was found, 25 yards from the murder scene. And the lab said that couldn't have been what slit the witness's throat, and it couldn't have been used, and it has no evidentiary value because it's been too long, and we can't get fingerprints or anything off of it, so you can throw it away. So that's his testimony, and we're all sitting there and say, okay, that sounds kind of odd, but whatever. So then Kent calls the lab tech he was dealing with. And he locks him in, right? Kent gets him locked in. You called the lab tech when, you did what, da-da-da-da-da. The lab tech takes the stand and says, no, I can't remember the police officer's name, but Joe Blow didn't call me. And, well, how do you know Joe Blow didn't call you? Well, he was very polite, and he always introduced himself and said why he was calling, and I logged all the calls, and here's my log. Well, he says he called you on such and such date. And he said, well, no, I was on vacation on that day, and you can look at my record. So now we're all getting really suspicious. And then he says, and I'm absolutely certain he didn't call me because we would never tell the police to destroy evidence. Now, this was local police. So what happens as a result of that is Kent, of course, moves. The prosecutor is pretty upset because he thinks this just went from a really great case to not so great a case. Kent moves to dismiss for prosecutorial misconduct, but I look at the two of them and I say, you better figure this out, because this is a train wreck. And so he gets a plea deal for his guy and gets the death penalty taken off the table, just because of his doggedness. So my point is, while Congress and or the courts through rules committees could have tailored a rule to avoid frivolous filings, they have not done so, and hopefully I've given you some reasons, for good reason. While a fair trial is an objective in a civil case, it's constitutionally mandated in criminal cases. Thus, defense attorneys can't worry about sanctions when contemplating what is in the best interest of their clients. They have to be willing to test the boundaries. Now, I'm not saying go out and file frivolous pleadings. That's the last thing we want. But we do want criminal defense attorneys to test the boundaries. And there's a long history of criminal defense attorneys doing so. Think about the sentencing guidelines or the confrontation clause, where criminal defense attorneys brought originalist arguments to a receptive audience, Justice Scalia, Justice Thomas, and others, and won a number of cases, getting things changed in the confrontation clause area, in the sentencing guidelines, in other areas that were in place for 20, 30 years if you're talking about the guidelines, or more if you're talking about confrontation clause jurisprudence. In fact, I would suggest if you go to law school and you plan on practicing criminal defense, and you don't, whether you agree with it or not, you don't learn about originalism and how to do it, you will commit malpractice. I think there's enough good arguments out there, and I've teed a few up myself, that attorneys are not making. For example, as I've talked to Lee about, I think, and I've written about, in an opinion called Morgan, I think the Supreme Court's reasonable expectation of privacy test is made up from whole cloth and narrows people's rights, because if you ask me if someone searched something, I don't care if you have a reasonable expectation of privacy or not. Maybe in the reasonableness prong some of this comes up, but it definitely doesn't come up in the search prong. So when they say when police go through your garbage, they're not searching, go out on the street and ask a lay person if they think the police are searching when they're going through your garbage. Of course they are. But as you all know, that's not a search. Why? Because you don't have a reasonable expectation of privacy under that scenario. Only lawyers could come up with this. So, I encourage you to learn from people like Professor Strang if you're planning on doing criminal defense. In fact, I think it's almost mandatory, especially with the composition of the courts today. Now, the problem in society today, in my mind, is indigent defense. This is where this happens the least. So what happened to me, my wife says I have a sickness and that I read law review articles, and I would agree, it is a sickness. No offense to the professors in here, but I like to read them and hopefully learn something. One of the law reviews I actually learned, probably the law review, the critical law review I learned more from than anything else, is as I was a judge, struggling with this, and struggling with the inequities of getting good counsel versus getting bad counsel. I read an article in the Yale Law Journal, God forbid, because Yale does, I love Yale and at times, but their law journal often publishes things that aren't worth reading, even probably my article. Although you all should read it. But a study by James Anderson and Paul Heaton, and it's fabulous. They're at the Rand Corporation, or were, and they did a study about how much difference a lawyer makes. And this is something I encourage you all to read. Because, you know, it's really hard, as they say, to quantify what the difference is. But what they did is they studied over 3,000 murder cases in Philadelphia. And in Philadelphia, 1 in every 5 defendants gets the public defender. 4 out of every 5 get appointed counsel. Okay, so what do the stats say? So this they can study, right? 3,000 murder cases over time where 1 in 5 is getting the public defender and 4 in 5 are getting appointed counsel. They can say, okay, let's put the public defenders up, this is what they did, against appointed counsel, and look at the results. Here's what the results are. If you had a public defender, you had a 20% less chance of being convicted. If you had a public defender, you had a 62% less chance of getting a life sentence. And if you had a public defender, they reduced the amount of time you spent in prison by 24%. Now, I would doubt lawyers make that much of a difference, but for my own experience. So let me give you a few examples. As a young judge, just got on the bench, right, from being kind of a career prosecutor, more or less. I worked at Williams & Connolly for a couple years, but other than that, I would say I was pretty much a career prosecutor. I get to the bench. Like I said, I've got a sickness, and I read things all the time. And so I guess all of you probably have it too, or you wouldn't have come to law school. And I get a pro se motion to suppress filed in a criminal case. And you know, pro se, if you have a lawyer, you're not allowed to file things pro se. But I'm curious, because this defendant has been screaming, and I'm just curious. So I take it home one night, and my clerks say, Judge, you really don't need to read that. I want to read it. And I read it. And I turn to my wife, and I say, I think this has some merit. She says, will you go to bed? So I go back and I call the defense attorney in along with his client. And I ask the government, I say, I just want to make an inquiry. Can the government leave? Da-da-da. And I asked the defense attorney, why didn't you file this? Like, your client's asking you to file a motion to suppress. Like, why aren't you filing it? I said, Judge, I reviewed it. I think it's frivolous. I didn't want to waste the court's time. I said, all right. Well, I'm going to appoint... I'm going to let you out because he really wants this filed, and I'm going to appoint Willis Coffey, who's a good lawyer down in southern Kentucky. And Willis says, all right, I'll look it over, Judge, and I'll do what's right. And I say, all right, Willis, I trust you. Just do what's right. So, fine. He goes away. A couple of weeks later, a motion to suppress filed. What does the government do in response to the motion to suppress? Speak up. I can't hear you. I know you got a mask on, but... Opposition? What? Opposition? That is a great guess. No.
Offers a deal.
It's another great guess. No.
Ignore this. Dismisses the charge.
Who said that? Yes. They dismissed the charges. The AUSA reviewed the motion to suppress, came to the same conclusion I came to. Of course, Willis did a phenomenal job. But his client didn't do bad. Like, if I gave it to you, you'd say, this is pretty good. And dismissed the charge. You know, I hate this thing times out, so my kids can usually set it up so it doesn't, but I'm out of town, so they can't do that, so I apologize. Let me give you another example. So one of the most fascinating cases in my experience as a trial judge is I've got a case ready to go to trial in Ashland, Kentucky. Anyone familiar? Anyone been to Ashland, Kentucky? No one. Well, someone back there. Excellent. So the one thing you should all do at some point is go to Kentucky because it is the greatest state in the nation. As long as we're recording that, I'm glad everyone in Ohio, where I grew up, heard that. I actually grew up in Toledo, and I love Toledo. In fact, I wore your colors today. Anyone notice? So, in this case, the defendant, at the last minute, pleads guilty. And I say, all right, and I take the plea, and it was hard to get him through the plea, and I go ahead. And I get ready for sentencing. And we come back to Ashland to sentence him, and I'm like, boy, he must have been really guilty because he pled and agreed to guidelines higher than his guidelines. And he comes in and he does not want to be sentencing. He tells me, Judge, my lawyer forced me to do it. Usually that's hogwash, right? But he says, look, like, why would I agree to higher guidelines than my own guidelines? I look at the AUSA, and the AUSA says, you know, I think we made a mistake. And I say, well, what's the remedy? And the AUSA, who's a great person, says, I think you should let him out of the plea. And then he can start over. Say, all right, I'm going to let him out of the plea, which is a rare thing that happens. His counsel and him don't see eye to eye. His counsel's like, he's crazy. I say, guess what? Go away. I'm going to appoint new counsel, and I appoint Pat Nash. Pat Nash comes in. He tries the case. Okay, so this guy is a minority, tried in Ashland, Kentucky by an all-white jury. He's not only a minority, he's someone in prison, and he's accused, while in prison, of possession of a shank. Okay, the deck's stacked pretty against him. Pat Nash, during trial, wants to play a video. Okay, so remember, he's accused of possessing a shank. The government plays the video where he's accused of possessing a shank. They wrestle him to the ground, or they search him, and then they walk off. And you see it, and you can't tell if there's really shank, but whatever. So then Pat wants to play a different video of him being arrested for drugs in the prison. I call Pat up. I say, can I talk to Pat alone? I said, Pat, now, Sixth Circuit's got this terrible precedent. They do. I've written about it, where if I don't stop you, and I know how great a criminal defense attorney you are, they're going to reverse me for plain error. So I want on the record why you're doing this. And Pat says, Judge, you just have to trust me. I want to play this video. Say, all right, Pat, I appointed you for a reason. Go for it. But it's on the record now. If they reverse me now, then they're even crazier than I thought. Yeah, I'm on the Sixth Circuit now. Don't worry. So Pat goes ahead and plays the video. In this video, he's arrested for drugs. They slam him into the ground. They cuff him. They pull the drugs out, and then they're walking him down the hall cuffed. Pat gets up in closing argument and says, isn't that funny? When you saw the video of him allegedly with the shank, they don't slam him into the ground. They don't cuff him, and we never see the shank. Yet, when he has drugs, they do all those things. How can that be? And Pat did a phenomenal job. Jury comes back, 45 minutes, hadn't even finished eating their lunch. Any trial lawyer will tell you all juries finish eating their lunch before they come back. They come back in 45 minutes, unanimous not guilty verdict, and then they ask to see me, and they want the prison guards prosecuted. So this guy went from pleading guilty to a sentence above his guidelines to not guilty. And after watching that trial, I can tell you he was clearly not guilty. The final one, just to give you an example of sentencing, and I've got strong views about sentencing that are different than most people you hear from. I don't subscribe to the popular wisdom that we should let everyone out of jail. I think there are criminals for a reason. They belong in jail. If they commit the crime, they should do the time. Having said that, the hardest part of sentencing as a judge is putting someone in jail for the first time, not putting someone in jail for the 20th time. And if you don't believe me, 20% of federal criminals have committed 18 or more crimes. So trust me, when I got those, I did not worry about putting them in jail. But when you get someone who you're putting in jail for the first time, it's a struggle. So let me give you an example of a case where an attorney made a real difference in the sentencing phase by going out on a limb. So we have the Mosley family in eastern Kentucky, and the Mosley family likes to distribute OxyContin. And there's a mom. She runs the show. There's a dad. He also participates in the show. And there's two brothers. One brother also involved along with his wife. The final brother, the baby brother, is not involved. Everyone but the baby gets indicted. They go to pick them all up. Before they can get there, the wife, who is on drugs herself, of the one brother, ODs and dies. They arrest the other three. The other three go to prison. Now, the one thing I'll tell you that I've learned in all my years of being a prosecutor and judge is criminals aren't very smart. And when the prison says they're recording your calls, they mean it. So when you pick up a phone and the prison says this call will be recorded, it will be recorded. The mom calls the baby and says, it's time you got in the family business. Here's how it's going to work. You're going to go and meet not only the family business, you're going to meet someone who's out of prison during the day on a work detail. You're going to give him drugs so I can distribute in the prison. He says, Mom, I don't want to. I really don't want to get involved. My wife will kill him. She says, too bad, and calls him all sorts of names and says, you need to do this for us. We brought you into this world. You have an obligation. He says no. She calls him back, ranting and raving. He finally, after multiple calls, all of which are recorded, gives in and takes the drugs to this woman. Guess who was waiting? Law enforcement. Yeah, we listened to those calls. So he gets indicted, and even though it's his first offense ever and he has a job, he's looking at substantial time. Why? Because under the guidelines, you bring drugs into a prison, guess what? You're going to have problems. And if I recall correctly, it was, for a first-time offender, it was like 47 to 56 months. Yes, in the federal system, we speak in months. Don't ask why. And so it was 47 to 56 months. So his attorney moves to continue sentencing several times. Then they show up. They want a half-day hearing. I'm like, this is crazy. What do you want a half-day hearing for? So first, he presents this guy's history. He files a sentencing memo, which surprisingly, to my surprise, many criminal defense attorneys do not do. Huge mistake. Remember, most of us are sick like you. We read everything, and memos ahead of time can really help. Files a sentencing memo laying out this guy's life. He then presents this guy's life. Then he calls someone from his wife's Bible study. And the guy from his wife's Bible study comes in and says, I've never met him. I say, well, why are you testifying? He says, talk to his wife a lot. I trust that if you, judge, let him out and give him a chance, I will give him a job. So I let him go, and I call the probation officer over, and I say, I don't know who this guy is. I'm in Pikeville, Kentucky, where I'm not from, right? I'm the sitting judge in Pikeville, but I'm also in Covington and London at the time. And I say, who is this guy? And he says, oh, he owns like 3 car dealerships, and the cemetery he's talking about that he owns, where he'll let the guy basically be a grave digger, he does. And so I say, well, what do you think? And he says, well, do you really want to put the whole family in jail? I say, if they're going to be dealing drugs, yes. And the probation officer says, I think you can give the guy a chance. That guy is the most upstanding member of the community. He's not going to take a chance unless he truly believes it. I say, okay. So I call the wife up, and I say to the wife, if I mess this up and he fails, we're all going to take heat, which is fine. I don't care. I got lifetime tenure. But if he sells oxy to someone that dies, I'm going to put him in jail for the rest of his life. And she says, Judge, you won't get to. And I say, what do you mean? She says, if he ever sells drugs again, I'll kill him. So I realize that she's the strength of the family, and I take a chance on it. Mr. Mosley now, and oh, by the way, every 3 months he has to come in and see me. Every 3 months that guy has to come in and see me. And they have to come in all the time. He starts going to church, probably good for him, with his wife. Mr. Mosley eventually runs the cemetery, starts an excavation company, him and his wife adopt his brother's daughter, brings her in. She's now in college. They're incredibly successful. More successful than I could ever imagine. Luckily, I put his parents and his brother in jail for a long time, so they've been not influenced. Oh, one other rule I had about this is he wasn't allowed to talk to them during the period they were in jail. And I say, is that going to be a problem? And his wife says, no. Can I tell them that? I get a Christmas card from them every year. They're doing wonderful. Like I said, the daughter that he adopted is in college. They've got 3 kids of their own, all thanks to an attorney who wrote a memo, went to the church and interviewed a bunch of people, brought a bunch of affidavits attached to his memo, and then brought one of the most upstanding members of the community who was willing, because of the Bible study with the wife, to take a chance on the husband. The guy's never even scratched the surface of committing a criminal violation again. So, what does all this mean? We need counsel that are both great and experienced. In Philly, one of the problems, if you go back to the study, was that appointed counsel did not have experience to know when to hold them and know when to fold them. They took bad cases to trial and didn't secure good deals, and vice versa. They pled out some good cases. You have to have the experience to know what cases to take to trial. You must be able to objectively analyze the case and tell the defendant what are in his or her best options. And you have to be candid with them. You need to know when, in other words, to hold them and when to fold them. The public defender pled 10% more cases, hence the lower sentences and things like that. Experience tells you when you have a triable case and when you don't. The other thing is, a lot of us leave law school wanting to crusade. Crusaders hurt clients. You have to have your client's interests at heart, not your own pet issues. Why we should care and why we have to do better. If the public defender represented every one of the 3,400 people in the study, 270 more people would have been acquitted. 396 people who received life sentence without parole would have received a lesser sentence. 6,400 less years would be served in prison, and $200 million would have been saved by the city of Philadelphia. So how do we come up with a solution that builds faith in the criminal justice system and allows us to have a system where we get the right attorneys in the right place? Well, I want to talk to you just for a minute about what our country is and then what our criminal defense system is. Our country, in spite of the unwise choices to try and change it, is still a capitalist system because we believe in people working hard and succeeding. Yet, our criminal defense system is a communist system. Let me explain to you why. The man chooses your attorney. That's what they think. How can you trust your attorney if the judge or some system is picking them and telling them, you have to take this person? My suggestion, which I stole from another law review, is clients get to interview. In other words, we treat indigent defendants just like we treat everyone else. We let them interview and pick their counsel. Now, there's perils with this, don't get me wrong. So what do? We have an independent panel, who's great at criminal defense? There's one uniform entity that's great, the public defender. But they obviously can't represent everyone. In fact, I think if we just put them in the system, that after a while, they'd be the most coveted. Everyone would be trying to get them, and people wouldn't think the public defender, right? We have all these movies that do damage to the public defenders, when in reality, they're great, right? One of the greatest legal movies of all time, if you haven't seen it, you should go watch it tonight. Well, do your homework and watch it on the weekend, is My Cousin Vinny. Right? But the guy that just graduated law school is the great attorney, and the public defender is a bumbling idiot. That's the public perception. Yet I'm telling you what the stats say. That's just not true. The reality is it's backwards. And so we can have an independent panel of attorneys pick who is in a book that the criminal defendants can then interview and pick from. Then make sure the criminal defendant signs off on the bills. Give them ownership of the defense. Just think, if they have to do that instead of judges, we won't be afraid of filing pleadings that are going to make judges' lives busier. The interest should be for attorneys in doing their best for their clients, not making our jobs easier. And competition for business is always better. This seems like an unremarkable idea to me, but yet in the criminal justice system, we don't compete for business. It also helps get rid of only the rich get justice system. Like your Professor Gilchrist, I worked at Williams and Connolly. We were always willing to test the boundaries. There was no criminal defense case where we wouldn't test the boundaries. He can tell you about it, and I can tell you about it. So, you might think this is kooky. I'm sure most of you do. Like I said, I'd come up with an idea that most of you probably think, what the heck's this guy talking about? I've tried it as a judge. In every death penalty case, believe it or not, I had the criminal defendant pick his counsel. And the way I did it is, you have to have in the federal system, you have to have a local attorney and a death-certified counsel. And a death-certified counsel is someone who has multiple experience. I literally would give them, here are the good attorneys in this area, just in the area of Kentucky, and then you talk to them, you interview people, you pick. It worked. They all picked their own. We had no issues. None. No ineffective assistance of counsel ever filed in those cases. None of that. I had the hardest defendant you've ever imagined. Complained and complained, and his attorney and him literally almost came to blows in the court. So I finally excused his attorney. I say, okay, I'm going to get you new counsel, which he wanted. And he said, great, Judge, get me someone good. I said, no, you pick. He looked at me like, I'm not picking my counsel. I said, no, seriously, you got to pick. He said, Judge, I don't know how to pick. I said, I'll tell you what. I'll give you a list of 10. Go ahead and call him. Talk to him. And come back. He said, all right, but I want to talk to you, Judge, after I go through the 10 and make sure I'm picking someone good. I said, I'm giving you a list of 10 good ones. You pick. So he picks Mark Wolander, a former prosecutor who's aggressive as all get out. And the attorney he had that he fired, by the way, very good attorney. Not someone I would say is bad. But I wanted to give him ownership. The result never changed. He didn't file an appeal. He never contested his sentence. Once he got the sentence, he wasn't unhappy. I guarantee the result didn't change. But in his view, the system treated him fairly. It gave him an attorney that did what he wanted and zealously represented him. But Mark is also courageous enough to tell him, hey, you go to trial, you're going to lose. Because guess what? They had him on video dealing drugs. And he didn't want to hear it until Mark played it out for him and told him how many cases he tried. The other thing that amazes me in our system, and trust me, there's no country greater in the world, yet two things matter in life as much as anything. Your liberty and your health, right? We only wear these masks and get vaccinated because we care about our health. two things matter as much as anything. Family obviously trumps all of that, but liberty and health. Yet, if I want to go to a restaurant after this, I can get on my phone, open an app, Yelp, and find a great restaurant, right? And usually it's pretty good. Like if it gets 4 to 5 stars, I think you'll all agree with me, generally it's pretty good. If I want to find a great lawyer or doctor, where's Yelp? Right? Where is it? How come we don't have Yelp? Now, if one of you invents it for lawyers and makes a ton of money, remember who gave you the idea. But I don't understand why we don't have that. Why not review attorneys? Why not review doctors? It would make perfect sense to me. Okay, so why at the Federalist Society am I talking about this? Because A, I think what everyone should be afraid about is putting innocent people in jail. And sometimes we as a society made a decision that beyond a reasonable doubt means sometimes you let the guilty go to protect the innocent. That should matter to everyone that cares about our Constitution and our country. Second thing is, for those of you who remain fiscal conservatives, it saves money. And lawyers shouldn't make a difference in our system. No offense, but they shouldn't, and they do. The study proves it. Ultimately, we as a society should spend less time, although it's important, on sentencing reform and more time on justice reform. Thank you. I know you have to be at class at 12:55, so I'll take questions for 13 minutes. If you don't, we're done. You can leave. I blew you all away. No one has any questions. Okay, back there. I can barely see you. Sorry, I can't put my glasses on or they fog up.
Presented your proposal to the defense bar there in Kentucky? I mean, what was their feedback where the client chooses their own attorney?
So, I've talked, here's the feedback that from people I've talked to is good attorneys think this is the greatest idea in the world and bad attorneys think it sucks. I mean, I hate to use that language, but that's basically the feedback. And so, attorneys collectively don't necessarily want it. And so I think it's something we have to start thinking about early on. It's a total reform to the system. They are trying it in one county in the state system. Not in Kentucky, but in the great state of Texas. And so Texas is trying it. I have not seen the results yet, but I know it was last time I talked to the judges there, and it's in the state system, and the professors who put the kind of indigent defendants proposal. That's at Cato, by the way. I think it's Stephen Schulhofer. This proposal together that they are helping down in Texas, and I think the results were pretty positive. I do think what will ultimately happen is you'll get less ineffective assistance of counsel challenges, if my experience is true. You'll get, and I did this numerous times, like whenever counsel wanted to, or clients were justified in getting rid of their attorney and the attorneys would tell me, yeah, there's irreconcilable differences, I always made them pick. And I think if you study those cases, 95%, no issues after that. And so, I think there's a way to do it. I think attorneys who are good love the idea, because they're going to get more business. Attorneys who aren't good don't really love it. I'm going to put these on so I can see. They fog up and I trip over the end. Someone come get me. Yes, back there. There's a mic. Oh, I forgot about the mics. I'm sorry.
How would you suggest we determine good attorneys and bad attorneys?
That's a great question. So the way I would do it is I would use public defenders who try cases across multiple spectrums with multiple attorneys to kind of create the book in the first instance. And then if this is why I think Yelp is brilliant, right, for restaurants, and I think it should exist for everything else, is then you'd also have peer review, right? Your fellow criminal defendants, you'd also, I mean, you are often housed in jail when you're picking your attorney, so there's a number of resources there. I think word of mouth will travel. What criminal defendants really want, in my experience, and maybe I'm wrong about this, and you all should tell me if you have a different view, and if Professor Gilchrist is here, he might, but they want someone that they feel cares about them, is going to advocate for them, and is going to go to bat for them. And if you give them that, if you give them some TLC, if you understand and have empathy for their situation, and you do that, I think they have a lot more faith in the system. And so that's at least my experience. And trust me, on the other end, like I said, if I get people who are bad people, I'll put them in jail for as long as anyone. And when I was a district judge, I was not afraid to give out stiff sentences because I didn't want them coming out and committing future crimes. And people who commit 18 or more tend to commit, or 82% of them commit a crime within 1 year. But the reality is everyone should get, if we believe in Gideon, and you know, you can debate that in the law school halls, but it exists for those of us in the lower courts, then it's got to mean that you get counsel that at least satisfies those requirements. But the real problem I have is just the inequity I saw in the Philadelphia study that those professors did. I mean, I'll argue with any professor about anything you all write, but numbers don't lie. And so I think we've got to take that study seriously, and it should be one that's the focus of all of our institutions in the justice system. Yes?
Hello. So I like your data. It's amazing. So another set of
It's not
data.
mine. I wish I could take it. Look, one thing judges do is we steal all good data from professors and others.
That's fair. So my question is, another set of data that happens across the country is that right now public defender offices all across the country are underfunded or undersupported and understaffed. So under your system and your model, let's say we do have a good public defender, like my boss is over there, hi. Let's say we appoint them all the counsels or people.
Is your
who
boss
choose-
a public defender?
He is. Multiple of them
Thank
are
you
here.
for
So
your service wherever you are. Go ahead.
So let's say, clients choose to pick, my boss or some good public defender, and now they become oversaturated with work because now they're the number one go-to, right? So now doesn't that lead to ineffective counsel? What is your thought on that? If we give people the choice to pick their public defenders, those public defenders get bogged down, and now they create ineffective counsel. What is your thoughts?
Yeah, no, I agree with you that that could be a problem. My solution would be if they're picking them, the money that represents the voucher in some form should go to the public defender, and as they do better and better, they should get more and more money, right? Because the voucher system, and we'll have less and less people on the outside. The one thing we absolutely have to have, as your boss will tell you, is some good private criminal defense attorneys, because there's multiple defendant cases, there's conflicts, you all may represent someone that later becomes a witness against another person, and so the reality is I would allow public defenders to get more money through this system by the way they're picked. Again, it's a meritocracy. We know the results, we know what public defenders do, but society doesn't believe it. So let the money will ultimately talk. And I actually think if the Cato Institute's right, the study and everything else, this will be a cheaper system for society. Okay, do you like that solution, or you want to push back on it, by the way?
I'm going to hold my thought.
Okay.
Hi, I was just wondering if you could clarify exactly what you meant by insinuating that we exist in a capitalist system and yet the public defender system is communist. I think that's very charged language that I guess I'm missing the nuance that you're trying to convey with it.
The nuance I'm trying to convey is that the capitalist system, it's survival of the fittest for everyone in society, right? In other words, you work hard, you succeed, you do the things you have to do. If we're appointing attorneys to represent criminal defendants, regardless of the merits, just because they're on a list that a judge puts them on or someone else puts them on. We're creating a system where we're handing out cases evenly, which is what we do, without any merit behind it. And that's my problem with it. That sounds like communism to me.
So then would you say that it applies for judges that have lifetime tenure like yourself, that because they're insulated from competition, that therefore they become ineffective?
I'll let others judge that. I don't know that we're insulated from competition. We have colleagues that disagree with us, but I would let you all decide that if we're effective or ineffective.
Hi, I was just wondering, the attorneys who aren't chosen to represent the individuals, let's say they're like the unpopular choices, what happens to those people who can't seem to get clients then? Like, do they just get fired, or what are they going to be doing while the ones that are chosen are working this entire time?
Yeah, and I guess it's a good question, and the answer is the same thing that happens in the civil system, which is in the civil system, we don't have a lot of appointments. And so attorneys go into a new line of work or do whatever. If you're not good criminal defendants, why should defendants be stuck with you is my question. So that's the way I think of it. But again, it is, as this gentleman said, there's some controversy to it. I'm asking that we take away livelihood from people in order to maybe keep innocent people out of jail.
Provides more accountability. I do like that.
It's a better way of saying it. Thanks. I'll use that next time.
Your Honor, thank you for sharing, and I appreciate the novelty of your approach, but isn't the simpler solution here to fund our public defenders' offices? If we could fund them in a way where they could represent the vast majority of defendants as we allow the prosecutor's office, say in Philly, to prosecute 100% of the cases, don't we close that gap somewhat?
Yeah, if we could do it in a way where conflicts weren't a problem, and we don't, in the federal system, and I don't know the state system as well, we literally will have 20, 30, 40 defendant cases in the big drug cases. The public defender can represent one person out of 40. Who wins the lottery is the question. And if I just have a problem with the fairness of that concept that one person wins the lottery and 39 lose it. Having said that, I absolutely think if we could create separate public defenders and get criminal defendants to understand these people have their best interests at heart. Those are two frictions I've seen a lot as a judge. The federal public defender, who are just amazing everywhere. People, you wouldn't believe what happens. People will mortgage their house or have their parents mortgage their house to fire the federal public defender, to go get an attorney I wouldn't hire to do anything. And it's just devastating as a judge as you watch this, and yet they have the right to pick their counsel. And so I worry about those things happening when people are forced to take counsel versus choosing it. But I do think if we could build a system where the public defender could account for most criminal defendants, I would have no problem with the system. So if you figure that out, count me as an advocate. Because I know the stats, and I know I've litigated against public defenders. They're great.
Judge, we're at 12:55. Okay. Please join me in thanking Judge Thapar.